Hi, my name is Craig Callis. I'm a freelance blogger and journalist, and I've been live tweeting the Judicial Review of the Digital Economy Act with the permission of Mr. Justice Kenneth Parker, who's presiding. Today is the first of 3-day judicial review of sections 3 to 18 of the Digital Economy Act, which put in place a regime to be enacted by statutory instrument at a later date, which would place a burden on internet service providers to help track people suspected of copyright violations through a regime of copyright infringement reports, CIRs, which would then be assembled into a copyright infringement list, which would be anonymised and then passed on to rights holders. Two internet service providers, BT and TalkTalk, have decided to launch a judicial review, which is being heard today in the High Court in the administrative decision. And there are a number of interested parties. Rights holders have been allowed to make submissions on behalf of the respondents, the Secretary of State for Business, Innovation and Universities, and the OpenRightsGroup, Article 19 and Consumer Focus were given permission to make submissions on behalf of the claimants, BT and TalkTalk. We've seen the two barristers for the claimants today, Anthony White QC from Matrix Chambers and Kieran Bill from Blackstone Chambers. Mr. White QC has been making submissions on 3 of the 5 grounds that the claimants have submitted. The first and the bulk of today's hearing was talking about the Technical Standards Directive. This places a duty, it's an EU directive, and it places a duty on member states of the European Union to notify the European Commission when they are bringing in technical standards for labelling or licensing that haven't been agreed at a European level. This is to give the Commission, to give other member states, to give corporations who work in the space outside of that member state the chance to consult on these technical standards if they're not general EU standards. And they can often hold up the process of bringing into effect standards in a member state by between 6 and 18 months. The argument by the claimants is that the Digital Economy Act itself brought into effect technical standards that would be refined and then regulated by statutory instruments at a later date. The government's response to this is that the Digital Economy Act simply enables technical standards to be drawn up in the Initials Obligations Code, the OEC or the code, at a later date. So the key legal question today was whether or not the technical standards that will be enforced are part of the Act or whether they are to follow later in the code. Is there enough detail in the Digital Economy Act about what that code will have in it to make it technical standards that should have been reported, notified to the European Commission in advance? They weren't notified in advance, and if they are deemed by the High Court to be technical standards, and the government didn't notify the Commission in advance, they will be struck down. So it's hugely important as to whether or not the technical standards will appear in the code later, or whether they actually appear in the Act at the moment. And the arguments today noted that the Act stipulates things that the code must have in it. It must have a regime for CILs and CIRs. It must allocate the cost of subscriber appeals 75% to the ISPs and 25% to the rights holders. It has a certain amount of detail. And whether that detail is enough to make it the substance of technical regulations on its own, or whether it's a pure enabling clause, and I think everybody accepts it's somewhere in the middle. If it's just an enabling clause, the Act is fine. If it actually goes so far as to be the substantive technical standards, then it will fall foul of the Technical Standards Directive and be in breach of EU law and be struck down. So that's the first of the 5 grounds. The second and third, also raised today, focused around other European directives. One in particular, the e-commerce directive. The e-commerce directive categorises internet service providers such as BT and TalkTalk as mere conduits. Article 12 and Article 13 essentially releases them from liability for what passes over their network and says that they cannot be held liable. So the legal question at play is whether or not the burden of the Digital Economy Act regime that will be brought into play by statutory instrument whether that burden falling on the ISPs, the fact that they bear the costs of subscriber appeals and managing the system, even though they only bear part of the costs, whether that constitutes liability. And the judge, a couple of times today, asked for the wording of the European directive to be given to him in the French and the German, saying that simply liability was an ambiguous term, whereas the French or the German words used to describe it would give us a better sense of what was meant by the European directive. So there's a question as to whether or not there should be any liability on ISPs as so-called peer conduits, and the question of what liability really means. Does it just mean criminal liability for distributing copyright, or does it mean liability for the process of having to regulate copyright infringement as a whole? And the third ground introduced today, Mr. White closing just before the recess this afternoon, looks at the Privacy and Electronic Communications Directive, or PECD. This is the directive that, in conjunction with the Data Protection Directive, regulates what's personal and communications data, what sort of protections it has from monitoring. A general monitoring obligation can't be imposed by member states on internet service providers or anyone else. So clearly the CIRs and CILs are in some sense monitoring. There are provisions to allow monitoring if it's specific cases. So if a rights on or a government authority thinks that somebody is breaking the law, they can certainly, nobody disputes, they can certainly apply for what's called a Norwich Pharmacal order, and they can find out what's happening on that particular IP address. The question is whether there will be so many CIRs. Mr. White QC today suggested there might be many millions. Whether there will be so many ad hoc instances that actually it goes beyond a specific monitoring obligation and actually becomes a general monitoring obligation, which would be forbidden by the PCD in conjunction with the Data Protection Directive. So we've had three broad grounds today. The first one on technical standards and whether they're actually in the Act, or whether the Act merely enables technical standards regulations to come in at a later date under the IOC. Secondly, whether or not the mere conduit exemption from liability means that the Digital Economy Act is a breach of the E-commerce Directive. And thirdly, whether Privacy and Electronic Communications Directive in conjunction with Data Protection Directive means that IP addresses, whether or not IP addresses are personal data, whether they can be used to pick up on identifiable characteristics of individuals, whether those data protection directives might in fact be breached by the Digital Economy Act. Over the next couple of days we'll hear the claimants also make arguments about the administrative burden and proportionality. Proportionality being a key metric both in EU law but also administrative law of judicial review. And then in the latter half of the three-day hearing we'll hear from the Treasury Devil, who's representing the government in this matter, and they will be responding to the arguments made by the claimants. So we should come to the end of oral arguments on Friday, and then we'll probably be looking at about 6 weeks or so until Mr. Justice Kenneth Parker hands down his judgment. It's almost certain that this will be appealed by whichever side is unsuccessful, and there also seems to be a strong possibility that because much of the substance of this is EU law, that either the High Court, or should it go to the Court of Appeal, might make what's called a preliminary reference to the European Court of Justice. This is where there's an area of EU law that's not clear, and the courts are able to refer questions of pure European law to the European Court of Justice, and they will determine what the EU law is, and then it's for the English courts to then apply that. That process of preliminary reference from the European Court can take on average more than 17 months, which would obviously massively delay conclusion of these proceedings and any implementation of the Digital Economy Act.